We're live.
Welcome back, everyone, to House General and Finance. It's the 15th of April still. And we are now having a committee discussion on H-169, which is the bill that relates, it's got many authors, but it relates to nationality. No, I keep it citizenship and the whether citizenship and immigration status in housing and in public accommodation. You know, we've had a lot of testimony on it. And let me put it this way. I think I've seen, if I might say, a lot of head scratching on everybody's part. And I've been asking myself, how do we think about this and how can I help? As chair. And so what I would like to do with the committee's permission is I want to take this kind of issue by issue. And I haven't done this before. And actually announce a problem, trying to articulate the problem that I know is in a lot of our minds about these things, and then propose not language, but concepts to think about. That's what I'd like to do today. And I'm not doing this as an advocate for these concepts, but as trying to help the committee, a framework to help the committee think this through. So what I think I'm going to do, I'm going to start with, in some ways, and each one, I don't know about you guys, but we've received lots of input from various citizens on all sides of this issue, and even amongst sides, quote unquote, sort of different perspectives. So that's why I want to. So first of all, I think rather than start with the question of citizenship and immigration status, as adding that as protected classes, I think I want to start where this bill starts in its current form, which is what forms of identification are going to be required. I don't see these as mutually exclusive or one before the other. I'm just starting there because it's easier to explain more than anything else. But here's the problem. I start with a problem and then throw out ideas, what I'm doing. The way the bill is written, it's kind of written very in the negative. It says a landlord or landlord's agent shall not ... request a social security number of an individual. Okay? So what's the problem? The problem was several. One was in the beginning, gosh, we need social security numbers to do our job, landlords were saying. But another was some huge majority of the transactions that occur probably will just the prospective renter will have a social security number. And so we don't want to overcorrect by creating a situation. And this is what many landlords write. Don't take away from me this tool. This tool is so simple and easy, et cetera. Don't take it away from me. Well, so one solution that occurred to me, this is not rocket science. It also came from, in fact, from one group of landlords too. Just make it clear that both options are available. Get a social security number or get a government issued ID. And so I tried my hand at sort of writing out, well, what would that mean? And again, I'm not proposing that what I'm about to read to you off of what I wrote is not legal language. It's just ideas, okay? So here's what I wrote, that the legislation could provide three things. One, that the landlord may require identification necessary to facilitate the investigation required for the rental transaction, including name, date of birth, prior rental history. Remember, those are the three things that they testified, that we heard testimony that if you have those, you can do a lot. In order to carry out credit reports and background check, that's the first thing. You see, I'm saying it affirmatively what landlords can do. The second is, to be real clear, a landlord must accept as such identification either a social security number or other government issued identification. A social security number may not be required except if required by federal law, and I have a whole section on federal. And then finally, and this was not in the bill, and I have to say there's a little bit of me in this, because I feel like our legislation should relate to the real world. And in the real world, the moment of truth is when people have to submit an application and fill it out. So I have the application forms or communications from landlords that landlords provide or make to prospective renters must make clear that either a social security number or another form of government approved ID is adequate for the rental transaction. In other words, I'm putting it into, hey, not only is this the rule, but your forms and communications have to make clear that that's the rule. Now, in all honesty, what that means is eventually landlords are going to have to change their rental code. Now, I'm adding a personal view here. I think our target here, if we were to pass legislation, is not a landlord who wants to discriminate against people who are undocumented or wants not to hire, or not citizens. Because I don't know if we can stop that or enforce it, because a landlord can do what they want to do and they can always find reasons. I think our target are people, landlords, who are either don't have strong feelings one way or the other, or actually wouldn't mind renting to those people, but they think that they can't because when they say they don't have social security numbers. That's our target. And that's why I'm kind of aiming at that group by saying, hey guys, change your form. This is the rule. You either go with social security number or with some other form of government issued ID. And I think as a practical matter, anybody who is a citizen is just going to give them their social security number. And if they're not, they're going to give them a passport or their green card or whatever they've been able to get if they're undocumented. So that's my thinking about form of education. Now, I can go on to the other issues. I'll tell you the other two issues, and it's up to you whether we stop here and talk about it or whether I go on with the other issues. The other two issues are the non-discrimination on the basis of citizenship or immigration status. How do we say it? What do we do with it? And the other is protection against liability for landlords and protection so they don't get stuck between federal law and state law. And there's also lenders, and we have someone who's interested in that in the room. So anyway, shall I go on, or do you want to just talk for a bit about forms of identification and shall we stop there and tell me what you think? Yes.
Well, I think the way that you're saying it feels like a lot more freedom than, like you say, the landlord can have the choice of, but to say that like you can't request this or you can't request that, and we hear testimony, other ways you can work around it. Why are we working so hard? It just puts more. So I feel like I feel more freedom when I hear it presented in that aspect. That if I want, I can rent to whomever I want to.
Gail?
But the landlord doesn't really have a choice. it's saying a social security number or. So if somebody presents the or, you can't say, but we also want a social security number.
What you can't do, here's what you can do and what you can't do with this kind of a language. Your application, number one, you have to take an application from someone who, if they give you their name, date of birth, prior residences, and one form of government ID, whichever it is, you got to take their application. The second is you can't not, I mean, it's talk about unenforceable, but you can't decide not to rent to someone simply because they gave you the wrong form of ID. In other words, you can't say, oh, I'm not going to rent to you because you gave me a passport instead of a government, instead of a social security number. You can't do that on purpose. However, there's nothing to stop a landlord from saying, you don't have a credit history and my background check doesn't check out that well. And this is a 1-unit, 1-bedroom place and you've got a family, or what, the whole host of reasons that they might have for thinking this person is not a match for them. They just can't discriminate because there's no social security. That's why I'm saying, I think in the real world, someone who really wants to discriminate
We'll
is
do
going to
it.
find a way to do it. But we're not aiming at that. We're trying to educate people that there are other ways to do this. How do people feel about that approach? Debbie?
Oh, my thoughts. I mean, being a small landlord or even a big landlord, you're in the business to rent. And you just want people that are gonna pay their rent.
Right, and you
So-
have to decide whether you
Yeah.
think they can.
Right, I mean, I don't know how many landlords discriminate for whatever reason. I mean, I can't say I know any, because we want to rent our places. And why would you turn away somebody that presents that I can afford this place and, and they show you?
Well, I'll tell you what, I'm gonna stop there and go on. Okay, but we can come back, or do you want Tom?
I think the language works better than as it's written right now. It just indicates that it is the landlord will accept one or the other.
Well,
Or
as long as you give them, you see, I think we have to say,
they can't, yeah.
they have to give them their date of birth, they have to give them their name, they have to give them their because what we heard was testimony that that's necessary to do a good credit report and background check. That you can't, and a government ID, you can't, we don't want to create a situation where someone could go in and say, here's my passport from Timbuktu, it's got my name on it, goodbye, They have to, I think there has to be a nod to the landlord's necessity of doing the credit report and the background check. An express nod.
We did hear testimony, did we not, as to whether it was a little bit harder to do the check?
I think that what we found was there were someone correct me if I'm wrong on this. My memory is, yes, it was fine with 2 exceptions. Rental history was harder to run down without a social security number. That if people could give you, somewhat harder. If people give you everything else, you can go back, but you can't go as far back. That's one thing. The second situation involves, which I don't think is a problem in Vermont so much. It involves a situation where you have many, many people with the same name. I mean, you know, in LA, we came across, I used to deal with real property issues and like, you know, how many Arturo Gomez's living in LA? Enough, are there enough so that they might have lived in the same address? Unlikely, but possible. No, I don't think that's ever much. Then there's protection against liability. What I heard and what I've read from various inputs that we've had and conversations we've had is that there's a bunch of different concerns. I'm going to try to tease this apart. One is, what if I have to ask for a social security number under federal law? And there are rental assisted housing where you do. Second, what if I don't want to, I'm speaking as a landlord, I don't want to get stuck in between a federal law and a state law. I don't want to be in a situation where to comply with the state law, I have to violate federal law. And I don't want to have liability under any of the laws. You with me?
Yeah.
Okay. So I wrote a bunch of ideas.
Of course you did.
Yeah, I'm just trying to say, how could you deal with this? Because I think today in all times, this is a concern. That landlords or lending institutions may require a social security number solely when the request is required by federal law to apply for housing benefits or loan, or where federal law otherwise so mandates. Where it's required in other cases, in such cases, the landlord or lending institution shall provide the applicant or tenant the reason for the information requested. That's one. There's actually like 4 things here. 2, except where federal law requires, landlords or lending institutions are not required to investigate or determine the national origin or immigration status of prospective current renters. Notice I didn't say may not. I said they're not required to, because there are situations, I think this is where your school situation comes in, where, you know, the school needs to determine the age of an entering student and they request a birth certificate or something like that. I don't want even there to be a hint that doing something like that is bad, but it's there. Then the provisions of, here's where the key, I think, the provisions of this ordinance, or whatever the hell we call it, this bill, this section, shall not apply to the extent prohibited by federal law, or where compliance with this law would cause landlords or lenders to violate federal law. In other words, none of this applies to the extent that there's any federal law to the contrary. It just doesn't even apply. And that landlords won't be liable for renting to individuals who are not United States institutions, and landlords are not liable for, for lending to them. So we're trying to protect here landlords and lending institutions from any conceivable situations which exists now or might exist in the future. That's there. You with me?
Mm-hmm.
The last one, which in a way is important, and it goes to the Senate bill. This H-116, I mean, the Senate bill is implicated here. H-169 has provisions which add citizenship and immigration status to the fair housing legislation and to public accommodations law.
Does not add
Not the Senate, the House.
the House
H169 does.
adds it to both.
Yeah, adds it to both. Okay. So what are the problems? I'm trying to be as express as I can here. With landlords, if with all of the liability protections that I described a minute ago, I don't think there's a personally, I think if we want to do it, we can. In other words, we can say that subject to the requirements of federal law, we can add those things to fair housing. I have here that lending institutions in making determinations to make loans shall not consider national origin and immigration status of the applicants in the application process or the decision to lend. Provided, however, that in making the decision whether to lend, the lending institution may consider the ability to sell such loans on the secondary market, or if a portfolio loan is an available option, may charge interest accordingly. So there's two issues here. One, and the representative of the banking industry has made this clear. One is there is right now a federal law which allows them to inquire into citizenship status as part of the information they gather. One approach, the one I use here, is to say, no, and you can under federal law, but you can't under state law. You can't require that information. However, you can make, that leaves them free. Cameron, help me out here. I think they would be free to decide on any normal commercial basis whether to make the loan or not. In other words, they can look at their credit history, they can look at their income, they can make them fill out the whole damn form for, whether they are qualified to make the loan, and they can refuse to make them the loan on commercial transactions. They just can't refuse to make the loan on immigration status alone and ask for it. But the second half is there because that problem I do not see us getting. That problem is a real world problem that we cannot control. And the real world problem is that most banks sell most loans to Fannie Mae or Freddie Mac or someone else. And Fannie Mae and Freddie Mac have as a requirement of their documentation, immigration status. What does that mean? That means, as I understand it, unless it's being misrepresented to me, and I don't think it is, it means that if you are not an American citizen, if you're a green card holder, they can't sell your loan. And they can't sell your loan if you're undocumented. What they can do is keep it in their own portfolio, but that's more expensive. And so I feel like we have to put that in there. It's true whether we put it in there or not. And I'm afraid that if we don't put it in there and we do tell them that they cannot take citizenship into account in the loan, we would be putting them in exactly the position we don't want to put landlords, which is caught betwixt and between federal law and state law. So I'm done talking. Thoughts?
No question. And this is. This chair. In a typical loan.
We can ask him a
application,
question, yeah.
Maybe. In a typical loan application, is it not common practice to ask for the most recent tax return,
Yeah, at least.
which will show. If they won't have a social security, there's gotta be some other device, and green card holders have to file a USA tax.
I got federal tax ID number.
Federal tax ID number.
And is it? Does that look the same on their form? Is it 9 digits like?
Chris, first of all,
I mean,
why don't you-
what I'm kind of wondering is
Chris,
that
tell us
not
if-
gonna be just,
Chris-
is that gonna be discernible from the tax form that they're gonna submit?
Chris, could you say your name?
Sure, for the record, Chris Delia, President Vermont Bankers Association. Yes, it would be different. It would be noticeable on the form that it would be different. It's
If your idea is,
because
Well,
by the time they complete a loan app, is the bank probably gonna know?
Bank's gonna know.
I can say yes.
okay.
we're going to know that as part of our customer identification procedures required under federal law,
Probably before it gets-
that we need to collect certain information to know that you in fact, so that we know you in fact are who you say you are.
Okay, yes.
It is a 9-digit number that is formatted as if it was a social security number.
It looks like so.
Okay.
But in the same way, I can tell whether you're from Vermont by the first 3 digits of the social security number. You can tell based on the first digits of. It is called an individual taxpayer identification number.
All right, and this is a safeguard against identity theft, among other things that would make.
There's a lot that
The
goes.
fact that you
knowing
have to
your-
do the check.
Correct. There's no way around the federal requirements of knowing our customer.
Okay.
And also commercial,
For good reason.
for good reason. Yes.
Backing up a little bit. What I heard you say was that federal law allows taking citizenship into account.
That's correct, isn't it?
I would just make 2 distinctions. You're using citizenship and immigration status in the same context. They're
Right.
not in the same context. Regulation B, which I shared with the committee, specifically speaks to the immigration status.
That's right.
And that's why we didn't object to citizenship included in the bill.
Right.
It was immigration status where we have the concern.
Well,
would
my
you get-
question was not about either immigration status or citizenship. My question was about allows. So it doesn't require, it allows.
My impression is you're right. My impression, let's be real clear here.
Please.
Under the proposal that I articulated, we would be contracting via state law what federal law allows. Federal law allows them to determine immigration status.
Under the context of right to repayment, we have the ability to look at your immigration status to determine the risk around the ability to repay that loan, aside from many other factors that you would consider. My concern with where you may be going, and we will certainly check on it, but perhaps legal counsel may want to look at it as well, is are you running into an area where federal law preempts what you're trying to do?
Right. That's the question. I think what I suggested was, I'm just throwing it out there. In other words, if we wanted to, I'm suggesting we could contract. It's permissive, so we could contract. I think, Cameron, we would have to confirm, and I'm sure we could hear from Chris or legal counsel. It's conceivable that the law that he's referring to, the regulation, I guess it's conceivable that although it sounds permissive, it's deemed to have occupied the area. And therefore that anything to the contrary in the state law wouldn't be valid. That's what you're getting at, right?
And I would go just slightly deeper, that sometimes in preemption discussions or cases, There's the context of preemption as it would apply to a national institution doing business in your state compared to a state charter. What that does, it sets up a situation where your nationals under preemption can do what they need to. Now your state charter banks are confined with
Right.
what they can do and therefore in a different competitive landscape compared to the rest of the banking
Right.
institutions in your
Okay,
state.
to clarify to everybody right now, we're not talking about selling loans, that problem. We're
Correct.
talking about the issue of how far can we go with banks? Yes, Cameron,
So I'll talk for a minute if I may.
please.
Okay, I'm gonna share my screen and share a few things. As I've listened to your testimony over the past few weeks, I kind of agree with the chair in the sense that I think you have two issues to potentially discuss and deal with.
Banks.
Just, I'm thinking in general.
Oh, in general, okay.
If you recall, and I'm gonna share my screen so we can look at language. This is 169 as it was introduced.
Do you want to make it a little bigger? Yeah.
And so the first issue is this one. This is section 1. So this is a change which says it's prohibiting landlords from requesting social security numbers. And there are questions and discussion about this. I'm not going to focus on this for right now. I'm just mentioning it, and then I'm going to pivot to some of what we were just discussing. I will simply comment that subsequent to the request and me, working on this for Representative Dodge, I have even done my own research and also listening to testimony from others and conversation on the Senate side. Under certain federal housing programs,
You have,
federal law is restricted and you cannot use those programs to actually fund individuals who are not here legally.
Right.
So that was actually brought up the other day. I don't know if you all recall, but you had an individual here who was talking about the issues with potentially renting to individuals who have people who are non-citizens in their household and the potential concerns with changes in federal law and that potentially causing problems for their ability to fund people who are here legally, but have someone illegal in their household and how the calculation of the rent is determined, et cetera. So I'm only bringing this up because I do think you need to address this issue in that there may be a requirement that a landlord needs to validate immigrant status, and they may not be able to do that without some sort of social security number or other, taxpayer identification number. So I do think potentially moving to language that would be drafted the opposite of this, where it's stating that you, landlord, shall take some sort of identification other than a social security number. And, to the chair's point, if you added language to require that a written application cannot only request a social, it must include a disclaimer that you can provide some sort of, separate identification number, et cetera. I'll comment there, though, that not all leases are written. And so, but that is what it is.
one, I just want to add, that was what I was trying to get at. We did have testimony, everybody, that indicated that there are federal programs. And when those programs subsidize housing, that's why I say landlords or lending institutions may require a social security number solely when the request is required by federal law to apply for a housing benefit or loan or federal law otherwise mandates.
And I've got a few different pieces of language, and I will just take the opportunity and give a shout out to Representative Dodge, who was also doing research through NCSL, et cetera. And so that was helpful to me as I was doing my own. So for example, though, this is in Minnesota, right? So it could look something similar to this. A landlord, for us, it would be, shall not deny a rental application solely because the prospective tenant provided an individual taxpayer identification number. There's some other language. For example, this is California, and I would recommend including something similar. So this is a landlord or agent shall not make an inquiry regarding immigration or citizenship status, but then it's got this language here that the section does not prohibit a landlord from complying with legal obligations under federal law and does not prohibit the landlord from requesting information necessary to determine, financial qualifications of a prospective tenant. I'm going to put that to the side for right now, just saying I think there are some things that we can.
I think that's very consistent with what I was talking about. Yeah.
So I'm going to circle back around to where we were at with lending. And I'm going to start with the language here. So 169. It has in the first piece, the public accommodations, adding citizenship and immigration status to the protections under public accommodation. This is in the Senate bill. And then you get to the unfair housing practices, and then it goes through and it adds citizenship and immigration status to all these subdivisions. The Senate bill only includes citizenship, not immigration status. But I'm going to get to the specific subdivision that we're talking about. Okay. Subdivision 6 is the one that we've been discussing as it relates to financial institutions. To discriminate, it is a prohibition to discriminate against any person in the making or purchasing of loans or providing other financial assistance for real estate related transactions or the selling, brokering, or appraising of residential real property because of citizenship, immigration status is what would be added there, okay? There are federal laws that overlay this, and you've heard some testimony on that, but I just want to bring them up and talk about them very specifically. For starters, I'm going to start with this section, which is 42 USC 1981. This is Civil Rights Act. It is, and I'm in sub A here, all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts as enjoyed by white citizens. Contracts. Real estate transactions are contracts, okay?
Right.
So all persons have the right to make and enforce contracts as enjoyed by white citizens. This is important. I'm gonna circle back to it. Civil rights legislation. And then you get to the Equal Credit Opportunity Act, which also states that it is unlawful for any creditor, I'm in sub A here, unlawful for any creditor to discriminate against any applicant with respect to any aspect of a credit transaction on the basis of national origin. Okay. What courts have determined, there are some distinctions between these two things. 1981 applies to individuals who are undocumented individuals in this country because it refers to all persons within the jurisdiction and it distinguishes those people against white citizens. So this law could be argued that it protects these individuals already, okay? Then we're going to get to the regulations that you've been referred to. So we have these laws that say you can't discriminate against these people in credit transactions and contracts. Okay. Then you get to the regulations here.
Those regulations are under what law? The banking.
It's under, my understanding is they're being promulgated under the Equal Credit Opportunity and the federal regulations that stem from that.
Okay.
Okay. So here you have under, this is, I believe, I remember the CFR piece 12, CFR 1002.5. These are the regulations that have been referred to previously. Apologies for all the scrolling there. A creditor, this is in sub E, may inquire about the permanent residency and immigration status of an applicant or any other person in connection with a credit transaction. So they can ask about the permanent residency and immigration status. Next piece, a creditor may consider the applicant's immigration status or status as a permanent resident and any additional information that may be necessary to ascertain the creditor's rights and remedies, okay? These are things that they're authorized to do under their federal regulations. So the question then becomes, for me, as I'm reviewing this, the question becomes, what is your language in 169 going to do And what is the behavior it's potentially going to change or implicate for these financial institutions? My understanding is the concern is by adding immigration status here, if they are complying with federal law, and complying is a strong word here because it's a permissive, federal law authorizes them to do something. If they don't do it, they're not in violation of federal law. If they were to inquire about immigration status in determining whether or not to issue a loan to a particular individual, the concern is you subsequently deny that person, they can sue and claim that you're discriminating against them based on their immigration status. At that point, it's going to go to court, and the financial institution is going to have to demonstrate to the court that that's not why they denied the person the loan. We didn't deny you. We're not denying every immigrant that comes in here and applies for a loan. We are simply taking that into consideration as we can under federal law and doing our risk analysis. I'm speaking outside my lane here. I don't do financial transactions like this, but in doing our determination of whether to issue a loan and looking at the risks that we have to take, we decided that that was a piece of the discussion, and we decided not to loan. A court, as you all are aware, and we've talked about in the past, these are very fact-specific cases that the courts are going to have to look into. The only cases that I've seen so far, as it relates to this kind of discussion in particular, banks were being sued because they were wholly, they wouldn't even take your application
Right.
if you were a non-citizen, even if you had, and these were what some of the complaints were about. I have someone who is a citizen who is going to, co-sign on my loan, and I can't even submit the application because your website won't allow me because I don't have a social security number. So they were being sued on those kind of basis. So what I'm just trying to bring you back and ground you to is the language here is saying they can't discriminate on this basis. And as long as they're not discriminating on that basis, they're treating somebody who is an immigrant or a non-citizen in the same way that they're treating everyone else, then I don't see any conflict with their federal authorization versus what they're doing. Your language does not say you can't ask for immigration status. It doesn't say that you're prohibited from loaning to individuals who are, not here illegally, etc. It's just the concern. What I've heard is it's the concern that you put this into statute. We go and we deny someone a loan, and part of that denial is because they're potentially, they're an immigrant, and that's a risk that, when we factor it into the equation, means that we're not going to loan to you, and then they're subject to a lawsuit. How that would then shake out in court is unknown. So I'm not here to say that my language here is the best and, there's no concerns here.
But I want to drill down on that.
And I want to make a few more just quick points. For starters, I want to go back to the federal language. Because again, when you talk about 1981, all persons within the jurisdictions have the same right to make and enforce contracts as enjoyed by white citizens. I haven't seen a case that strikes down these federal authorizations based on a 1981 action. So from everything I've read, these are permissible. You can inquire about immigration status and not be in violation of 1981. And I'm also cautioning on the equal credit opportunity because it's specifically limited to national origin. These two things are different. And as I've read them, the courts are not determining immigration status to be national origin. They're determining them to be different things. So where I'm getting at is the discrimination that H-169 is contemplating putting into statute may already be prohibited by federal law. I haven't found a case that's determined that, and I'm not advising you that's the case. you, as your, your jurisdiction to determine whether or not it's appropriate to put this in the statute on top of what's already there in federal law. To the things that you were just discussing, I haven't found a case that preempts state law in this area. That's not to say that it can't be argued. It's not to say that a court won't make that determination. What do I mean by that? As we were kind of just discussing on the sideline here, when federal law is in direct conflict with state law, federal law is preempted under our US Constitution. So states cannot enact laws that are going to be in direct conflict with federal law. There are times when they may not be in direct conflict, they just may be in slight conflict. It's difficult for me to comply with this and this at the same time. Courts try their best to not find preemption in those instances and try to determine whether an actor can comply with both. And then lastly, as you were discussing, there is in areas where the federal government, the regulations kind of are so, there's so much depth and breadth to them that they kind of overtake the space, and states can't regulate in those areas. I have not found a case that has determined that to be the case under this and other state laws in California. There are a few cases in California that kind of directly talk to and address these issues.
Are there, does California, a couple of questions. So the question, which I think you're in, a question is, does this, what's it called? Equal Credit
Opportunity
Act, as implemented by the regulations, preempt state legislation? And you're saying, I haven't found a case that says.
I have not found a case yet that.
And there is, you say in California, language, or in other states, language, which restricts the rights, not the rights, the permissive activity contemplated in these sections.
I have not found one. There was
Wait, can I just interrupt for a sec? I have found that language in Washington, New York, Illinois, California. I'm not sure what you're asking exactly. Whether.
Can you try again?
Sorry, Siri went off. Are you saying that you haven't found any state language that adds immigration status to their credit?
No. I asked him, Leonora, whether he had found any language in the other states relating directly to the question of whether the Fair Credit
Equal Credit Opportunity Act?
Equal Credit Opportunity Act preempts. Is there any indication that there's state laws, any of these states have laws on lending like we're contemplating, which would restrict the range of the ambit of activity that's contemplated in the federal law?
So to that question, and as Representative Dodge just mentioned, there are states that have added similar language into similar provisions of their statute. One in particular, unfortunately, I wasn't able to kind of download and pull it up here, so you're just going to have to bear with me while I shuffle some papers for a second. In Washington, for example, that's one that I found. They have a section here. It's the right to be free from discrimination because of, includes citizenship and immigration status, is recognized as and declared to be a civil right. The right shall include, but not be limited to, the right to engage in real estate transactions without discrimination, including discrimination against families with children, the right to engage in credit transactions without discrimination. So specifically similar language to what you contemplated in H-169. And then a separate section in Washington, which says it shall be an unfair practice to use citizenship or immigration status concerning an application for credit in any credit transaction to determine the credit worthiness of an applicant.
That's about as close as you can get.
Right. And so what I What I will also say quickly, though, Representative Dodge, where I was going, as I was saying, I haven't seen a case where a federal court has determined that preemption strikes down these provisions, at least in accordance with banks that are operating interstate commerce. These are also newly passed. My understanding is most of this legislation has passed, within the past few years. And so there's not, I can't guarantee you that that's not going to happen simply because other states have passed similar legislation.
Right. Okay, so I wanna lay out I wanna try to clarify by laying out some options with respect to this particular thing that is banks and lending. One approach, which I think Cameron is referring us to, is just simply to say that it's kind of like in the last law that he read, basically saying banks cannot discriminate on the basis of immigration status. That's one approach. I'm going to go back over these, but one is just to say boldly they can't discriminate on that basis. A second, which I was proposing, not necessarily advocating, just throwing out there, is to go further and say they really can't ask about immigration status or consider immigration status in the application process or in the decision to lend. A third option would be to say that they can't consider it in the decision to lend, except to the extent it relates to the ability of the applicant to make the loan payments at the time of the loan. The disadvantage, okay, so let's go back over these one at a time. As to just saying, hey, you can't discriminate on this basis, and leaving it unsaid whether you can request this information. The advantage of it is it doesn't appear, it's just sort of silent on what they can do. They presumably can ask for it. And as Cameron said, and I agree with you, what that means is if they were sued, they asked and they denied a loan and they were sued, they'd have to show that they had other reasons for doing it.
If the plaintiffs can demonstrate that they've never approved an application for anyone under any circumstances, that would be evidence that leans towards they are discriminating.
Right.
Yes.
So I guess I don't know whether it's an advantage or a disadvantage, let's call it an attribute. An attribute of this approach is just, it leaves open the question, it leaves them somewhat subject to litigation. It leaves them somewhat subject to litigation. The second approach, which goes further and says, you can't ask.
Advise against that.
What?
I said I would advise against that. I think of your options, that one is putting you closest to a direct preemption
Right.
challenge.
Because the law expressly contemplates that they can ask. Okay, that's the second option. I have to say, as a litigator, in some ways, it also protects them. Because if they don't ask, then they won't get sued on the basis that they've been discriminated. But they will find out. And they will look at their credit history, et cetera. In some ways, if they don't ask, they won't get sued.
But I would put it in this situation, I think the concern there is on a direct preemption issue, because if they do ask and then they are sued because they're violating state law,
Then-
they're complying with federal law,
Right,
or they're doing what federal law authorizes
Yeah,
them.
but then I agree. If they disobeyed the state law, they'd be more in trouble. And then the third option, I'm not advocating any of these, I'm just trying to clarify. The third option with respect to these lenders is to say, they can't ask, they can't use, just to expressly state in the statute what their defense would be, as you said it, to say they cannot use this information except in the determination of the ability to pay.
I think you could, if you are wanting to alleviate the concerns that you've heard, I think that is probably your most direct path to getting there. If you want to include you, lender, can't discriminate on this basis, then it would be adding some language that states that it's not similar to the federal language. It's not a violation of this section to consider as part of other factors that are being considered when determining whether to issue a loan.
I suspect, without knowing that, and Lenora, I would appreciate your thoughts here. I suspect, without knowing really, that proponents of this law, beside yourself, would probably be more comfortable just with the first approach of just saying you can't discriminate on this basis and leaving how it works to the future, rather than contemplating that you can, if you put in except, if you say except to the extent that it's necessary for determining whether they can pay, some might argue that it provides a roadmap for discrimination. I don't know. Do you have any particular thoughts?
I think that the way that the language was modeled on states like Washington and California that have this language in various either civil rights codes or fair housing codes. And, those live within all of the other statutes in the state. And yeah, they are not proscriptive in how you carry this out. And I think on purpose. And so, just as there's no like specific proscriptions for like, right to be free from discrimination because of race, creed, color, sex, military status, sexual orientation. Like we're not spelling out all of the potential scenarios of, somebody mistook somebody or somebody made an assumption. I think that it makes the most sense to just add it to the list of categories and then, have a statement at the end that, exempts you generally on federal law. I think that it'll stand up better than saying you can't ask for it, or you can you can request a social just as you could, as any other form of ID on the rental part. The credit part, I think that we do have I think case law that says national origin is sort of treated as citizenship or immigration status, and that the feds have spoken pretty clearly that that you shouldn't be doing that, and they don't. I think that Vermont would be aligning itself, not really adding much, just making things more clear. And so I think what Cameron is explaining makes sense, that it's not that we're, and when we heard testimony last or 2 weeks ago, it sounds like they do want to make loans to, they would make loans to somebody, say, with a green card who's lived here for 40 years and works here and has a great credit history. And so they feel like they're not discriminating. They would only be disqualifying somebody or providing a higher credit rate or a higher, interest rate to somebody who may not have as much of a rich credit history. And they're worried that doing that is suddenly going to be illegal. I mean, I don't think that would stand up in court. And so I just think that a fear of something frivolous coming at the banks is less of a concern than what we can see happening, as we've heard, that there are a lot more cases as we heard from the Human Rights Commission that people are facing discrimination based entirely on immigration status. And so that's the why of this bill. And so that's why the language can be more broad. And I think I provided a statement of like some potential language that, part of why this is a no, like the landlord shall not, is because at one point our state legislated against being able to just charge an application fee that's not related to the cost of taking a credit history, for instance, or doing a background check. And so that's why it's as a landlord shall not, because it's a continuation of shall not charge an application fee. And so the language that I had come up with that I just sent to Ashley, but I know
I
that
guess my
Yeah.
two questions. One, Cameron, do you have any opinion about the part about Fannie Mae, Freddie Mac selling the loan and all that? I mean, I just felt like, I guess anyway, do you have any opinion about it?
I will say it this way. And I want to make sure I'm clear, and this isn't in response to anything Representative Dodge said. I'm just going after her, right? I don't want to minimize, or I don't want to sound as if I am minimizing the potential for financial institutions in the state to, be at risk in their current practices as it relates to who they are and are not lending and how they're going about doing their lending. And this is a specific reason why, when we're talking about if there is a prohibition on reselling these mortgages to Fannie Mae and Freddie Mac because they require that the individual must be lawfully here. Adding this in is potentially going to open up an institution in the state who's choosing not to issue loans because the only way they can operate, effectively is by doing so. And so we can't operate because we have to be able to repackage and sell these loans. In order to do so, we have to validate, and we can only lend to someone who is here legally. Therefore, we're not going to make loans to individuals who, are in some sort of citizenship limbo or immigration status limbo. I think you are opening them up to a potential lawsuit, even if you simply go with your first option, which is to just add the prohibition. So my point is simply to say, I don't want to minimize that. You have the individuals in the room, and they've testified, you could speak to them. So I want you to know, I'm not trying to minimize that in any sense. To the question, in my opinion, it's going to shape out based on how the facts are happening on the ground. Is the bank saying, and I'm just using bank as the general term, you're not here as a citizen, therefore we don't even take applications and loan to you? They're putting themselves at risk of a lawsuit. If they're saying that and I don't know how this works on the resale, this is the last piece I'll make, Mr. Chair, and then back to you. And here's where we're straying into regulation of financial institutions. This is not my subject area. And I can have, I've had conversations with our counsel, Maria Royal. This is her area. We've had some general conversation about this topic. I potentially defer to her or ask you to have her come in and give you her thoughts. Will Fannie Mae and Freddie take it if they're co-signed by somebody who is here legally? I don't know the answer to that. So it's really just going to depend. Are you just excluding wholesale because it makes our life more difficult as a financial institution, then yes, I think you're potentially putting yourself into running afoul of that law. I do also think, sorry, Mr. Chair, I've interrupted you twice. I do also think it's potentially problematic to put in there that you can ask for this for the purposes of reselling your loans. Because I think that exemption potentially kind of swallows the protection, if you will.
My concern there simply is, if we're going to provide landlords protection against conflict between federal law and state law, we have to provide credit institutions the same thing. If it is true that, and I do think you should talk to Maria. If it is true that they can't sell their loans, then they have to be able to take that into account, or we are in fact putting them between a rock and a hard place. And it may be that that would be overused, or, you know, that's always a possibility.
Well, and here's the reality too. Again, I'm just thinking about this logically, so forgive me, I don't operate in financial institutions, so on and so forth. You know, it's not prohibiting them from selling their loans that they're making to individuals who are citizens. It's just saying that, you know, you can't discriminate against these people. So if they meet all of your other, presumably your criteria for issuing out loans, and I don't know, I guess the argument is, yeah, but we don't, because we have to be able to repackage them. So we don't, you know, we don't loan to individuals who are not here legally. And I think argument could be made then, and these are the cases that I've seen in California recently. I mean, someone could argue, arguments have been made in court that you're already violating federal law by doing that. You know, you recall the memo that, you know, Representative, you know, Dodge had kind of, you know, brought up to the collective. You know, there was a memo issued, if I could find it, you know, by the Consumer Financial Protection Bureau and the Justice Department, which said that, you know, be careful because doing that may be considered a violation of federal law. I agree with the testimony that's provided previously. This isn't federal law. A memo issued by a federal agency doesn't carry the force of law. It wouldn't surprise me if this has already been rescinded, right? But I'm just saying that, you know, that's why I was bringing up the federal laws that we looked at, the 1981 section and the current, you know, consumer you know, the credit act, because arguments can be made that by excluding individuals who are here that may not be citizens, you're violating federal law as it is.
I guess what I would like, for purposes of producing the next draft of this bill for consideration by the committee, because I don't think it's getting on, I think to be useful, we need another draft just to talk it through and see it. I think you should talk to Maria and circle back to me, and just, you know, Maria may have an opinion about this. I'm kind of inclined, absent an opinion to the contrary, to leave an exemption like this in just for consideration by the committee. And then the question is, which is worse, not to have an in? You know, is it more protective? Is it less? The only thing I'll say, I guess I can say this. If we want to do this bill, we want a bill that can pass the House. And we want a bill that gets out of this committee with strong support, can pass the House and be signed. Otherwise, what are we doing? And I think that is why I don't think language phrased entirely in the negative will do that as a political matter. I think Leonora was absolutely right. In terms of pure drafting, it's easiest. The reason laws are often stated in the negative, it's easier to be precise when you're saying in the negative. But I do think that affirmatively referring to what landlords can do is an important part of this, or else it will, I just think that it's a political matter. Now, that's my personal view. And I guess, Cameron, what I would suggest, if it's okay with the committee, is that Cameron take a crack at a revised draft. And let's take a look at it and talk to Maria and call me if there's like something weird comes up, like Maria tells me we're all crazy. Okay? Or Chris is absolutely right, or has been totally misleading us, or whatever.
Could I just state one more thing for the record? That, but you know, what I've heard in the context of a lot of testimony is discrimination in the case of rentals.
Yeah,
I want to make it very clear to the committee that this is not about submitting applications to institutions. Anybody, as I said in my testimony, can walk in and submit an application. This is about the factors that go into making a decision. And when you look at immigration status under the credit analysis and the right to repayment, that is a legitimate issue in today's context, as is the case with Fannie Mae, Freddie Mac. So I appreciate your consideration of those issues because they are very real today. A very brief example, in the world of commercial lending, the SBA just came, well, I should say.
as it was.
The federal administration came out with a new policy that says you will not lend in the context of SBA to somebody who does not have legal citizenship status here in the United States. This is the real conflict we find ourselves in. So my concern is if the analysis is that we can't sell to Fannie Mae and Freddie Mac, and that is right in their regulations, then we know the discrimination discussions that have occurred in this very building and the potential for lawsuits on an industry that is regulated and examined on a routine basis for the very issue you're talking about. So I want to have that on the record just as a closing
Thank you.
comment from me.
Gail,
So if someone were to co-sign for someone who's an immigrant, would that be acceptable? Someone that is a US citizen, has a good credit rating, background check is good, and they're co-signing for someone.
It would be no different than if I were to co-sign a loan for one of my daughters. I, as the co-signer, had the same legal obligations as that other individual. Does that address the credit risk? You betcha.
how about Fannie Mae?
That I don't know. I'll
That's what I
check on that.
I
Because
think that would be
if there's
interesting. to know.
failure to perform, I'm coming after you as the co-signer.
Yeah, that's ask Maria. I would really like to know what she.
Question of Chris, and I want to, I'm glad that Chris is here for this, is his expertise. I'm trying to understand whether the Freddie Mac Sallie Mae resale of the credit, whether the loan is whether the inability to resell makes it impossible to have loaned, the fact that you're not going to be able to resell the loan, whether that is makes it impossible for you to make the loan, or whether you could still choose to give the loan, but maybe, you know, what would that look like?
It depends on the bank. Some banks only sell loans, and in which case they couldn't do it. Other banks can keep loans in their own portfolio, which is what you're really talking about, but it's.
Even take a bank or a credit union out of it. What if you have a mortgage broker in the market? All they do is facilitate the transactions. If they're not holding anything in portfolio because they sell it to the secondary market, this has implications.
Right, the only banks that could do it would be banks that they do keep some loans in their own bank. They don't sell them. And there they might charge more interest.
Right.
I mean, very often if a loan is a little unusual, you know, it's a different kind of a loan for some reason. It's just not saleable. Now, what that means is it's hard to find a bank. You got to find a bank that's willing to do it. They'll charge you a little more interest and they'll keep it in their portfolio, which means they're out the money. See, the advantage of selling your loan is you're getting the money back.
Can
That's
I
how
ask
you
about
recapitalize.
mortgages? Can I ask whether there's any distinction? I'm just because everyone's in the room, I think it's something that I've been wondering, and I wonder about it when I don't have Chris in front of me. So I'm just taking advantage. I hope you'll pardon me. But the guarantee that somebody has when they're borrowing for a mortgage is the house itself, right? Am I? And
The
so
mortgage is a contract that says, I don't pay you.
you
well,
get
I
the
owe
house.
you, you can take the house.
And stuff like that.
Right,
That's
and
right.
so is that necessarily a loan that
don't
you're
like-
gonna resell?
You sell a mortgage, when you take out a loan, there's two documents. One is called a note. The note is the document by which you promise to pay, how much you're gonna pay every month, all that stuff is in the note. The mortgage is the document that says what happens if you don't pay the note. I don't know, Chris, when a bank sells the loan, do they sell the mortgage?
Yeah, the only time the bank would still be involved is if they retain servicing.
No, but when they sell both documents,
Yeah.
they sell them together.
Right.
They're packaged together, Lenora, these two. One is the mortgage is just the remedy if you don't pay. The note is what says you pay.
And the property is collateral for the loan. If you exercise your right against that collateral, it's at minimum of 3-year foreclosure process in Vermont with mandatory mediation with the borrower to try and give them an opportunity for coming out with a workout plan, if you will. If that borrower is not here, I don't know how you do the mandatory remediation.
Does that, in other words, when you sell the loan, you sell everything. And you do it because you get your money back and you're out of the transaction. The bank is out of the transaction, except very often the bank has a little contract by which for a certain little bit of money, they continue to service the loan. That, you as a borrower don't see this happening. You just make your payments to Northfield Savings like you always did. But in fact, the money that Northfield Savings gets from you is going to whomever, Fannie Mae or whomever. We can talk about this more. It is now past 4 o'clock. This committee has been at it for a long time. Are people comfortable with us moving ahead just to see what the next draft looks like?
Yes.
Okay,
Yes.
all
Thank
right.
you.
We will put it all on camera.
Thank you, Cameron.
Yeah, easy, just don't mess it up. Okay, we are not offline yet. Well, but I have you. So guys, tomorrow, Wednesday at 9 o'clock, we are hearing S-125. S-125 is an omnibus labor bill that came from the Senate, okay? It's not very long. It doesn't have a lot of labor in it, but it is there. And what we're not hearing it. It's an introduction and walkthrough. And then we will have a little more testimony on 127, which we started with today. Okay? And then that'll take us through lunch and then there's the floor. At this point, do we have anything after the floor yet scheduled? We'll just have to see whether that works for us or not. Any last questions before we do the A word?